So, two judgments which came up around that time, which are important to understand this. One is a judgment by the name of Khadak Singh versus State of Uttar Pradesh. Now, this Khadak Singh happened to be a dacoit. He was charged of dacoity, and post the charge of dacoity, since there was lack of evidence, he was acquitted. But his travails did not end with that, as you know, and this is where things will come into play, that the Uttar Pradesh police regulations had two regulations in it, one 236 and 237. 236 was a very interesting kind of a regulation which talked about the fact that suspects, their homes could have domiciliary visits from the police to check out whether the suspect is there or not in the night. They could also have the constabulary to watch the suspect, to watch his movements, where he is during the day or whether he is returning back home in the night. So they were maintaining a record of that as well. Either within his home or near the precincts of his home, a watch could be kept. The regulation also provided that in case of movement, an inquiry could be conducted in relation to where all he had gone. And the police officer could also conduct an inquiry into his activities as to how he is earning his living. What is his source of income? In a way, it was all very pervasive and intrusive into the privacy of a person, intrusive into the basic rights of a human being. And 237 went a step further. 236 also spoke about the fact that a history sheet could be opened of the suspect in terms of what he had done and what he had not done. Now, you people will find a parallel in relation to what is happening in relation to the Punjab police rules here in Delhi. 237 went a step further when 237 said that surveillance could be maintained of a history sheeter. So, a surveillance can be maintained of a history sheeter was even more obtrusive. So, Khadak Singh decided to challenge all this, and a challenge came against these regulations of the Uttar Pradesh police. And Justice Subbarao was on the bench. And Justice Subbarao, while dealing with this issue, gave an expansive definition of the concept of liberty to begin with. Not only that, he also very interestingly and very progressively held that it does not matter that the person was of a bad reputation, or a man who already had a case against him and who was a suspect was bringing this petition. It made no difference. He said that as far as the concept of liberty was concerned, the concept of liberty was equally good for him as it was for a person who was a good citizen. He said that does not make a difference. That was one major aspect. And further, he said this, that what could happen to a person of disrepute today, there is no guarantee that the government would not do this in relation to a good and honest citizen as well. So therefore, there is a need to interfere and intervene. And he also said this at the same time, that as far as liberty is concerned, it is a right, essentially, which should be free from encroachment. And what he meant by encroachment directly or indirectly. So to a great deal, when he dealt with all this, he again touched upon the interplay of 19. the interplay of 19 with 21. More interestingly, post this Khadak Singh's matter, and Khadak Singh happened in 1963. The citation is AAR 1963, Supreme Court 1295. Today, most of you, whenever you file a petition seeking quashing of history sheet proceedings in a certiorari under Article 226, your essential grounds are based on what Justice Subbarao said in Khadak Singh's matter. That is where all this started. Now, going a little further, Khadak Singh happened in 63, but at the same time, a very interesting case came before Justice Subbarao, and this related to a person who essentially was undergoing imprisonment, and he wanted to, while being confined in prison, he wanted to write a book. He wrote a book, and the book was written in Marathi, and it had a very interesting title in Marathi, which came to be, when you translate it, it translates as Inside an Atom. It translates as Inside the Atom from Marathi. Now, this book, he wanted it, having written this book in prison, he wanted it to be published. The state had objections to this, saying this, that he did not have this right to get it published. And this came up before Justice Subbarao. And when it came up before Justice Subbarao upheld this right and said that Article 19 gives him right of freedom of speech and expression. Article 21, and very interesting interpretations he gave. He said that even if you essentially say that 19 is bracketed and 19 cannot be, the effect in relation to 19 cannot be looked into, while you are placing a challenge in relation to 21, he said that liberty, in fact, constituted, even those rights which are there in 19 relate to freedoms. So, for a moment, if you think that those rights are at this point of time not available to you because of the fact that you are in custody, he said that 21, when it talked about liberty, it talks about the residual rights which are left in terms of that freedom. That freedom being suspended at the point of this point of time, being in a different bracket, you cannot look into them. But minus all those freedoms, there still remains a reminder of liberty within 21. And in that reminder of liberty in 21, will have certain elements of all those freedoms which are there in 19. So this is the way he expressed it. There were 5 such aspects which he delineated, whereby he showed the interplay that how wide was the concept of 21 of liberty, and how it within it had all these rights in a way, but if you do away with those and you can't look into the others, it will still have a reminder or residual part, which in that residual part will include certain aspects of what is contemplated in 19 in a way. So that interplay of 19 and 21, without disturbing the judgment of A.K. Gopalan in 1963, of 1950s, in 1966 this judgment was delivered, AIR 1966, Supreme Court 424, and it is titled State of Maharashtra versus Prabhakar Pandurang. State of Maharashtra versus Prabhakar Pandurang. This is a very interesting judgment where it talks about the person's right to express himself while in custody. Because using Gopalan, the state said that he does not have a right of freedom of speech and expression. When he is confined, though these two things are in separate brackets, so if he is asking for publication, in a way he is asking for his Article 19 right, which is not available to him. So Justice Subbarao culled this reminder part of liberty in 21 and said that yes, it can be published. So this was a very interesting development which happened during this period. Now, having said that, the next case, which is a kind of a landmark in that journey that I was talking of from A.K. Gopalan till Maneka Gandhi, comes Rustomji Kovasji Cooper versus Union of India, which is otherwise known as the bank nationalization case. Because before this, today you all go to scheduled banks, nationalized banks. So all this nationalization happened around this time, and this nationalization case is again a watershed or a kind of a landmark because it revisited Gopalan. This revisited Gopalan, and on revisiting Gopalan, it overruled Gopalan. It not only revisited it, he overruled it. And Fazal Ali's view, Justice Fazal Ali's view, the minority view, that is why I said that minority views or separate views of judges, their logic in arriving at a particular conclusion is important because it sheds light, probably at a later stage, for better wisdom to dawn and probably take to those views instead of what was the majority view at that point of time, as was done in this case. So in the bank nationalization case, the court returned a verdict saying this, that various fundamental rights are not to be considered in isolation. You can't say that 14 has got nothing to do with 19 or 19 has got nothing to do with 21 or... They said that it is not that they exist in isolation, they are all interdependent. And what was negated in A.K. Gopalan by Justice Das, I read that passage also to you. What was negated there by him was then thereafter revisited and said that no, this is not the right view. And here they introduced the object and effect test for the first time. They said that every challenge has to be looked into in terms of the object which the legislation was intending to achieve, and also the effect which it would have, not only in the right which is being claimed to be infringed, but also in relation to all other fundamental rights, since they are all interdependent with each other. So the view which was taken in Gopalan was completely overturned in this judgment. And this, I say, was the first progressive step which was taken. What Justice Subbarao did earlier was the precursor. He was in a way showing the way. And that way was taken, that path was taken by this judgment in overruling Gopalan that this is not the right way. So in a way, to a certain extent, you can find that the due process of law is slowly creeping into the system. It is yet to creep in as such, but yes, you can see that it is coming in. There are now definitions which are getting expansive, there are definitions which are getting more embracive, and there is innovation which is happening, which you see in this case. And as I said, 1970, 1 SCC 248. So, from 1950 onwards, Gopalan in fact held this way for nearly 20 years. Though there were discordant notes in between in 63, 66, which was struck by Justice Subbarao and others. But finally Gopalan got overruled after 20 years. So this is the development which I am tracing. So this is the first step towards that. Now interestingly, in 1970 this happens. And then some tumultuous events happen in the polity of this country. Now what are those tumultuous events? The tumultuous events which happened was that in 1971, there was a massive mandate which was given to Mrs. Gandhi. An unprecedented mandate. And in that unprecedented mandate which was given, there was the ability in the legislature to have the strength to effect amendments. And as I had earlier spoken to you, when I spoke about the fact that the first judgment which came in at that point of time, post the coming in of the constitution, like now I am tracing A.K. Gopalan to Maneka Gandhi, there another stream I had started from Golaknath. In the Golaknath's matter, it had been ruled that fundamental rights will not be effect to change. The amendments will not affect fundamental rights, was a view which was taken at the time of Golaknath. Article 13, when I was discussing, the view that was taken was that since 368 talks about amendment, 368 is also law as defined under 13. And 13 talks about the fact that no law can be made which will abridge or take away fundamental rights. So therefore, fundamental rights cannot be abridged or amended, was the view which was taken by the majority of Golaknath. Golaknath was holding this way at that point of time. In 1971, a huge mandate was given, and immediately post that came what is known as the 24th Amendment. I spoke about that also a little bit when I had dealt with these issues then. So this huge political mandate brought in this 24th Amendment, and it was clearly an attempt to overrule what was stated in Golaknath's matter. Because what it tried to do, the 24th Amendment was amending Article 13 and amending Article 368. And saying this, that 13 would not constitute, Amendment 368 would not constitute law as envisaged under 13. And they brought in 13.4 and gave powers to the Parliament, unbridled powers, to add, vary, or even revoke or repeal any of the provisions of the Constitution. So that is what 24 did. On the heels of 24, at that point of time, on the heels of 24 also came 25. The 25th Amendment, because till that point of time, any acquisition of land, today as you know, land acquisition laws, compensation is paid, fair compensation is paid. Whenever the government takes it for a public purpose, one, it has to show that it is for a public purpose. And two, whenever it acquires land, it has to give market price or fair compensation. These are the two concepts on which it goes, all land acquisition laws. But the 25th Amendment, in fact, brought in a change. It said that what would be paid would not be compensation. The word compensation was changed, and the word, instead of compensation, was substituted with the word amount. And at the same time, this was also brought in, that the word amount is being brought, and at the same time there could be no challenge in relation to the amount, the compensation given in the form of an amount or in the form of any other thing. Like for instance, they could give land for some land. They said that both these things will not be subject to challenge before a court of law. So this is what the 25th Amendment did. And interestingly, was also introduced around this period a fresh amendment which came by way of 31C. Now 31C was even more of a wider import, because what 31C did, 31C said that any law which was made by the Parliament with this object of furthering directive principles of state policy, Chapter 4, directive principles. They were not even fundamental in that sense. They were directive principles of state policy. So if they were to further directive principles of state policy, then that law which would be made with that intent also cannot be challenged in a court of law. So look at the manner in which the basic rights were getting scuttled by way of amendment after amendment which was coming around that period. And all this happened because of that huge mandate which came in Parliament, which gave the ability to the Parliament to make such laws. Now, in terms of Gopalan, of course, Gopalan said something else. Here, these amendments say something else. Now, when this was happening, then, in the meanwhile, a challenge had to be placed, obviously, and a challenge was placed. And this came up before the Supreme Court. And when this came up before the Supreme Court, this came to be decided in this particular landmark case where 13 judges of the Supreme Court gathered and debated on this issue as to whether the Parliament could be vested with such powers of amendment. I had my reservations to the Keshavananda Bharati judgment when I delivered the previous lecture. I had stated that. I stick by that view that to quite a great extent, Keshavananda Bharati, to a great extent, Keshavananda Bharati gave the Parliament large powers of amendment, huge powers of amendment. They more or less accepted all that was being said. But fortunately for the Indian Constitution and for Indian constitutional law, they developed this concept of the basic structure. They said that yes, powers of amendment can be given and extensive powers of amendment the Parliament will enjoy, only to be limited to the extent of their not being able to amend the basic structure. Now, interestingly, the basic structure, again, like the due process, is a concept which cannot be put into a bracket. That this is the bracket. Features can be said, but it gives a scope. There is a scope which is there, and it is on that scope that everything thereafter was built, on that edifice. The edifice was built on that foundation. So it was a foundation stone which was to a great extent capable of supporting a large edifice. And that edifice slowly gets raised brick by brick thereafter. Where now subsequently when I deal with other aspects, I will show how the edifice is being constructed, how it is being raised brick by brick, and how now it has developed into a pretty large structure where substantive rights are also being brought in. Various substantive rights which I spoke of when the American Constitution I was speaking of the due process, you will find a similar kind of parallel post Maneka Gandhi. So here the foundation was laid in Keshavananda Bharati. So therefore Keshavananda Bharati is one of the important judgments to the extent that there was one saving grace in it, and this saving grace of the basic structure. Otherwise, literally everything had been surrendered. Because Keshavananda Bharati went to the extent, I had stated in the previous lecture also, that even fundamental rights are subject to amendment. 368 is constituent power, will not come within the ambit of 13. They said all that. And we have our great constitutional lawyer, Nani Palkhiwala, to thank for having developed this concept and argued this concept and brought in this basic structure. And this basic structure test was then thereafter in a review which was filed thereafter, was again re-argued by him and re-agitated by him and upheld. The review was dismissed, where the state brought a review on this, that was also dismissed. And so the basic structure came to stay. How it finds an expansion in Minerva Mills and others will be a part of discussion thereafter. But before I end this section, there is one more very interesting development which happened during those times and which has a lot of bearing in relation to personal liberty. What happened around the times of emergency? Because Mrs. Gandhi's election got challenged in the Allahabad High Court. I still remember it was the Shah Commission or something. And post that, she brought in the emergency in 1975. And with the emergency, when she invoked Article 359, came in certain laws, draconian laws like visa, maintenance of the Internal Security Act. And preventive detentions happened and arrests also happened under visa and various other statutes. Various high courts in this country were flooded with petitions because fundamental rights had been suspended. During this period, fundamental rights were suspended, but yet writ petitions were filed on the basis that these statutes which provided for these offences, there was a violation of the provisions of those statutes itself which afforded the filing of writs. On that basis, writs were filed. And all these writs then thereafter came for consideration in a way before the Supreme Court in a very famous or infamous judgment called ADM Jabalpur. This ADM Jabalpur is a judgment which you can term it as a famous judgment or an infamous judgment, depending on how you interpret it. Famous because of what Justice Khanna wrote as a dissenting judgment and lost his Chief Justiceship, but became revered for all times to come for having had the guts in those days to write a judgment of this kind which was against the tide. And infamous for what the other four wrote. So therefore I say it's a famous judgment as well as an infamous judgment both. Because the majority view in that judgment was that during the course of emergency, it is akin to a war. And it's a suspension of fundamental rights and all other rights as a situation which is akin to war. And they said that when that emergency period is on, even an habeas corpus will not lie, seeking your liberty. Your liberty can be curtailed to that extent. In fact, one of the judges in that Jabalpur judgment happened to be Justice Chandrachud's father, Chief Justice D.V. Chandrachud thereafter. And when Justice Chandrachud wrote the judgment on right to privacy, he revisited Jabalpur, ADM Jabalpur, and dissented from his father. Although he termed it that it was a very difficult thing to dissent from an erudite man, but my views are different. And he felt that if today Justice Chandrachud had seen this judgment, he would have probably concurred with it. So this was the view which Justice Chandrachud now presently took in terms of ADM Jabalpur. And Justice Khanna, in fact, during the course of the arguments, had put a very interesting poser to the AG at that point of time. That supposing you say that liberties can be taken away and the state is entitled to do that, and there is a suspension of everything. He said that how do you prevent abuse? Supposing a policeman under this garb of, you know, protecting the integrity and sovereignty of the country, he says that yes, I am depriving the liberty of some person, but actually why he is depriving the liberty is because of his personal enmity with the said person. Now, in that kind of a scenario, how can you safeguard? What is the safeguard that is there? He posed a poser of this kind. So he wrote a dissenting judgment saying, at that point of time, from the main view, saying this, that no, not all rights can be suspended like this. A habeas corpus can lie in terms of liberty. So therefore, ADM Jabalpur also, to a great extent, is a judgment which is a landmark judgment in terms of the dissenting view which was given. And once again, it validates what I am saying, that at that point of time, maybe the majority may carry sway in terms of sheer numbers. But yet, the wisdom of that sole person who is dissenting, the wisdom of the sole dissenter, may thereafter be vindicated subsequently. As we saw, was vindicated in the case of way back in A.K. Gopalan's matter by Justice Fazal Ali, and then subsequently vindicated again by what was stated by Justice H.R. Khanna. So with that, I conclude today's lecture, and hereafter we will deal with the further journey towards Maneka Gandhi by going into Minerva Wills and other cases leading up to Maneka Gandhi, and how this concept then thereafter developed. Thank you very much, guys.
Thank you, sir. Thank you.
We'll end with this today.
Thank you, sir.
Thank you for a patient hearing. Good day.
Thank you, sir. Thank you, sir. Thank you.
Thank you.